Will the Senate please come to order?
Sounds ominous.
Yeah, it does. In lieu of a devotional, we will take a moment of silence. Thank you. Are there any announcements? Seeing none, we have Senate Bill S65, an act related to energy efficiency utilities. Let's see. On the calendar for notice and carrying an appropriation under Rule 31 is referred to the Committee on Appropriations. We now have SR 12, Senate Resolution reaffirming the friendship between the state of Vermont and Taiwan and supporting enhanced Vermont-Taiwan bilateral relations and Taiwan's participation in international organizations, offered by Senator Clarkson and others. Please listen to the reading by title only.
SR 12, Senate Resolution reaffirming the friendship between the state of Vermont and Taiwan and supporting enhanced Vermont-Taiwan bilateral relations and Taiwan's participation in international organizations.
Now you've heard the reading of the resolution. The chair in his discretion will treat this resolution as a bill and refer it to the Committee on Economic Development. We now have JRH3, a joint resolution authorizing the Green Mountain Boys State and Green Mountain Girls State educational programs to use the State House facilities on June 26th. It passed the House on March 18th, 2025. Was read and adopted by the House. Please listen to the reading of the resolution by title only.
JRH3, joint resolution authorizing the Green Mountain Boys State and Green Mountain Girls State educational programs to use the State House facilities on June 26, 2025.
Now you've heard the reading of the resolution, and the chair in his discretion will place this resolution on the calendar for action tomorrow. All right, we now have Senate bills for introduction, S-130, an act related to expanding the National Guard tuition benefit program, introduced by Senators Rahm Hinsdale and Weeks. Please listen to the first reading.
S-130, an act relating to expanding the National Guard tuition benefit program.
Now you've heard the first reading of the bill, and it is referred to the Committee on Education. We now have S-131, an act related to approval of an amendment of the charter of the City of Burlington relating to the possession of firearms, introduced by Senator Baruth. Please listen to the first reading.
S-131, an act relating to approval of an amendment to the charter of the City of Burlington relating to the possession of firearms.
Now you've heard the first reading of the bill, and it is referred to the Committee on Government Operations. We now have House bills for referral. We have H-125, an act relating to reporting on the energy transition. It passed the House. I cannot read the date, but it passed the House. Oh, January. I'm going to have to use my glasses on this one, guys. January 30, 2025, introduced by Representative Sibilia. Please listen to the reading of the bill.
H-125, an act relating to reporting on the energy transition.
Oh, we've now heard the first reading of the bill, and it is referred to the Committee on Natural Resources. We now have H 231, an act related to technical corrections to Fish and Wildlife statutes. It passed the House of Representatives on March 19, 2025. Please listen to the first reading of the bill.
H 231, an act relating to technical corrections to Fish and Wildlife statutes.
Now you've heard the first reading of the bill, and it is referred to the Committee on Health and Welfare. Excuse me, that is referred to the Committee on Natural Resources and Energy. We now have H 259, an act related to preventing workplace violence in a hospital. It passed the House of Representatives on March 19, 2025. Please listen to the first reading of the bill.
H 259, an act relating to preventing workplace violence in hospitals.
Now you've heard the first reading of the bill, and it is referred to the Committee on Health and Welfare. We now have H 396, an act related to creation of the Molly Beatty Distinguished Service Award, passing the House on March 19th, 2025. Please listen to the first reading of the bill.
H 396, an act relating to the creation of the Molly Beatty Distinguished Service Award.
Now you've heard the first reading of the bill, and it is referred to the Committee on Natural Resources and Energy. We have H 482, an act related to Green Mountain Care Board's authority to adjust the hospital's reimbursement rate and to appoint a hospital observer. It passed the House of Representatives March 21st, 2025. Please listen to the first reading.
H 482, an act relating to the Green Mountain Care Board authority to adjust a hospital's reimbursement rates and to appoint a hospital observer.
Now you've heard the first reading of the bill, and it is referred to the Committee on Health and Welfare. Orders of the day. We'll be passing over S71, and we will be moving on to S117. An act related to rulemaking on safety and health standards and technical corrections on employment practices and unemployment compensation. It was introduced by the Committee on Economic Development, Housing and General Affairs, March 13, 2025. Affecting the appropriations of the expenditures of the state, the bill was referred to the Committee on Appropriations, which reports that the bill ought to pass. Listen to the second reading of the bill.
S117, an act relating to rulemaking on safety and health standards and technical corrections on employment practices and unemployment compensation.
I recognize the senator from Chittenden, Senator Chittenden.
Thank you, Mr. President. Your Senate Committee on Economic Development, Housing and General Affairs brings forward this technical corrections and miscellaneous labor bill. The administration testified on and submitted a memorandum outlining several technical corrections needed to various statutory sections. These corrections, while perhaps seemingly minor, are important for modernizing processes, streamlining operations, and ultimately better serving the Vermonters who rely on the Department of Labor. Let me now walk through the sections of the bill. Sections 1 through 4, I'm going to speak to in a group. This is about expedited rulemaking for VOSHA, Vermont Occupational Safety and Health Administration. This bill would permit the Vermont Department of Labor to more seamlessly synchronize the adoption of standard issued rules by the U.S. Department of Labor's Occupational Safety and Health Administration that the state, Vermont, is required to adopt. Our OSHA adopted our state plan is unique to the rulemaking process with a specific requirement for us to adopt the federal OSHA rules. When we elected to become a state plan back in 1971, a year after OSHA was federally adopted, we committed to federal OSHA to take responsibility for the regulation of occupational safety and health within the state by agreeing to the requirement of this plan. In that agreement, we committed to adopting rules that are at least as effective as the federal rules and standards. But we can still make them more strict. This doesn't change that. By taking responsibility for regulation of occupational safety and health, Vermont is able to take a more proactive approach of helping employers to fix issues rather than penalizing them after finding a violation among other benefits. However, VOSHA, Vermont's Occupational Safety and Health Administration, has a very small staff, and this rule synchronization will help them manage their constrained resources. If our Department of Labor wants to adopt a rule or standard that is more protective of health and safety than the federal standard or rule, or if the Vermont Department of Labor adopts a rule or standard for which there is no corresponding federal rule or standard, then this rulemaking synchronization process would not be eligible. To match existing precedent with other Vermont agencies with similar rulemaking tracks, your Senate Economic Development Committee added a provision making clear that allowing any 25 persons or more to request that the synchronization process involve the traditional and more time-consuming rulemaking process. Under this more expedited process, the Vermont Department of Labor still must provide notice of the proposed rule to interested parties, including affected employers and trade organizations, post the proposed rule or standard on the department's website for the last 30 days. They must provide at least 30 days for members of the public to submit comments. And upon completion of the expedited process, the Department of Labor must file the rule or standard with the Secretary of State and retain all papers and records used or created in adoption of the rule or standard for at least 1 year following the adoption of the rule. This bill includes a prospective repeal, the technical term for what I more colloquially know as a sunset, all right, for an expedited rulemaking process to sunset or prospectively repeal 3 years from now, just to ensure that this doesn't cause any concerns. It'll come back to whoever's in this chamber then for potential continuation. Just some more background, I'm talking more about these sections because I recall the most amount of committee discussion on these sections, so I'm elaborating on sections 1 through 4. I just want to put in context this as well. Since 2019, VOSHA has adopted 5 federal OSHA rules in their entirety, okay, in order to meet this requirement under our state plan. Those rules had to do with changes to crane operator training and certification in the construction industry, electronic submission of injury and illness records, updates and revisions of the beryllium standard for general industry, updates to the beryllium standard for the construction and shipyard industry, and improved tracking of workplace injuries and illnesses. The point being that the federal OSHA does a really good job, and they require us to adopt at least their required rules, and that's somewhat unique in our rulemaking process in the state of Vermont, or compared to other processes. So I just want to highlight, VOSHA has a very small staff, and this is just to allow them to better synchronize with the federal rules while not disabling any of our capabilities to further enhance, strengthen, or alter, or adopt our own VOSHA standards. That's 1 through 4, and I have less to say about the other sections, so this might move a little bit faster going forward. Section 5 has to do with investigations of complaints and of unpaid wages. The Commissioner of Labor determines, if the Commissioner of Labor determines that an employer has willfully withheld wages from an employee, then this language will make that says the Commissioner shall require the employer to pay the additional amount not to exceed twice the amount of unpaid wages. Previously, it was an option. Now we're making it a shall, which does come to us from the administration, as well as some committee discussion on the topic. Section 6 is a technical correction about employment and wages. It provides that calculating the yearly minimum wage, the percentage increase of the consumer price index for each U.S. city shall be rounded to 1 decimal point. Again, to make this consistent with with the U.S. Department of Labor. The Commission of the Labor's Authority in Section 7, this is actually from Bill S6, which I believe was introduced by our Windsor delegation. Our Windsor delegation highlighted this, and the administration did testify on it. This just removes the Commissioner's authority to recommend a sub-minimum wage for individuals with disabilities. This enabling language was adopted in the 1940s and has not been employed by the Commissioner and has been superseded by our since adopted American with Disabilities Act. It's just really just cleanup language. Section 8 is a notice of potential layoffs. This clarifies that a covered employer is one with 50 employees in total, not just in Vermont, but worldwide. For them to be covered, they would have to still have a Vermont employee. But if you have 50 employees, regardless if they're all in Vermont or not, that would make sure the notice requirement for potential layoffs would then be triggered. Relatedly, this also reduces the number of employees affected by a layoff or shutdown to trigger those notices from 50 to 20 to trigger the notice requirement. This does not change the threshold for the number of employees to be mandated to be covered by this requirement. It's still 50, but what it's saying, if 20 Vermonters are going to be laid off, it will trigger the notice requirement, which did come to us from the administration as a request. Sections 9 through 16, really unemployment is about unemployment compensation. These 8 sections update several sections of Title 21 to allow for electronic notice and distribution of documents. Currently, many notices must be mailed, physically mailed, which is both inefficient and outdated. This is allowing claimants and employers the option for electronic communications to modernize our operations and improve efficiency. Section 17 has to do with the employer's experience rating records and disclosure to a successor entity. This bill requires that if a successor employer divides the operations of an existing business between 2 or more entities, the successor employer shall designate one of the corporate entities as the successor for unemployment insurance purposes. The Department of Labor has been seeing instances where out-of-state employers are purchasing businesses in Vermont, trying to split them into 2 new businesses in order to lower their UI tax liabilities. The consequence is that one of the new businesses could be provided a new employer rate, thereby allowing the entity to dump its UI rate, tax rate, and pay fewer contributions than legally required. Moving on to section 18, rate based on benefit experience. This is a technical correction. It revises statutory definition of the highest benefit cost rate to align with the federal definition. The U.S. Department of Labor has identified an issue in how the annual tax rate schedule for unemployment insurance for employers is calculated. The current language uses the highest amount of benefits paid out, but this may not be the best indicator of the health of the UI trust fund. The necessary language will now reflect, or that is being proposed, reflects a benefit cost ratio as the metric to determine the appropriate tax rates. This bill amends that language so that the benefit cost ratio is based on that. Section 9 has to do with disregarded earnings. This is a really technical correction as well. It provides that wages earned while a claimant is partially employed shall be rounded down to the nearest dollar when calculating the amount of disregarded earnings, which actually helps, so it reduces the amount that they would lose out for just the earnings applied to their otherwise benefits, so it just rounds down the dollar. Our statutory language currently requires earnings reported on a weekly claim to be rounded to the nearest dollar. This is causing some confusion and inconsistency, as claimants are sometimes required to report earnings higher than they actually receive, reducing the amount of benefits they are eligible for. That too came from the administration. Section 20 has to do with the short-term compensation program, which is, I believe, why this did go to appropriations. And so I believe that will be reported on after I finish talking here. Some of you that have been here for a longer amount of time might recall the short-term compensation program, which was designed to help employees avoid layoffs by providing unemployment insurance benefits to workers when they just need to reduce their hours. This program was placed on hold in 2020 due to outdated systems and has been in a dormant state as the department could not implement the program with its legacy systems. The short-term compensation program is being designed into the new system with the Department of Labor, and the department is proposing to bring this back this option for employers to avoid layoffs. So this allows them to avoid layoffs by having their employees that might get reduced hours accessing some unemployment insurance while retaining their employment. Section 20 ends the current dormancy of the short-term compensation program effective upon completion of the project to implement the modernized information technology system for the unemployment insurance program. And I believe through conversation that potentially could mean some of the revenues from that program could go out if the program is taken advantage of, and that's where maybe my colleague in appropriations might speak to or not. It's not a direct appropriation, it just means some funds could come out. Section 21, information technology modernization. This moves the deadline for implementing a modernized information technology system for the unemployment insurance from July 1st of this year to July 1st of 2026. They are very close, just needs a little bit longer, which is often the case with many projects, and they are on track, and they just asked for this extension. Section 22 has to do with effective dates. Your Senate Committee on Economic Development, Housing and General Affairs heard from Dirk Anderson, Director of Workers' Compensation and Safety, Department of Labor. Michael Harrington, Commissioner, Department of Labor, as well as our very talented Sophie Zadatny, our Legislative Counsel, Office of Legislative Counsel. And your Committee on Economic Development, Housing, and General Affairs did vote favorably on this bill 5-0, and we encourage this Senate to concur. I'm also told, this is a new committee for me, my chair says that when doing a miscellaneous bill, that a haiku is appropriate. So I'm going to try my first haiku on the floor, which I'm going to admit was from AI. Labor rules adjust, tech updates, wages change to, efficiency soft. Thank you, Mr. President.
Recognize the senator from Grand Isle, Senator Brennan, for the report of the Committee on Appropriations.
Thank you, Mr. President. Your Senate Appropriations Committee reviewed S-117 and found it to have a de minimis effect on the state dollars and voted on a 6-0-1 vote to find it favorable, and we ask for your support.
The question is, shall the bill be read a third time? Are you ready for the question? And Senator from Addison.
Thank you, Mr. President. I just want to note that I think the senator from Windsor is expanding the haiku tradition now that she's chair. It used to be just on purely technical corrections bills. And so now this is a little bit of an expansion of those haiku powers. Just wanted to note that for the new senators.
So noted. Senator from
This is a
Windsor.
technical corrections bill. And in fact, it is an expansion, but only to another committee. And so with that, I will offer my technical correction haiku. DOL needed, statutes aligned, updated, now technically correct.
Are you ready for the question? No more haikus? If so, all in favor signify by saying aye. Aye. All opposed signify by saying no. The ayes have it, and you've ordered third reading of S-117. We now have S-12, an act relating to sealing criminal history records. It was introduced on January 17, 2025. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as set forth in the calendar today, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on, I don't have that, no, Appropriations, Finance. 12, Finance, second page, got it. To the Committee on Finance, which reports it has considered the bill and recommends that the bill ought to pass when amended as recommended by the Committee on Judiciary. Listen to the second reading of the bill.
S-12, an act relating to sealing criminal history records.
I now recognize the senator from Chittenden. Senator from Windsor, Senator Hashim, for the report on the Committee on Judiciary.
Thank you, Mr. President. Unfortunately, this was, excuse me, this is unfortunately the longest bill report I've ever written, but I believe I've condensed it down because I know we have a long day ahead of us. S-12 is our sealing and expungement bill, which was a component of the Public Safety Omnibus Bill. It was also described as one of the most important requests within that bill. And in order to fully understand the walkthrough of this, I do have to establish what the difference is between sealing and expungement. So to seal a record means to essentially put it behind a lock and key where it remains inaccessible to the public eye, except for certain limited circumstances, which I'll describe later. To expunge a record means to completely destroy all traces of it and then deny it ever existed. In other states, sealing and expungement are used as interchangeable terms. So for example, the Michigan State Bar Foundation describes expungement as sealing a record to make it non-public, except that it can still be accessed by a court, an agency of the judicial branch, law enforcement, a prosecutor, the AG, and the governor. But Vermont does it a bit differently. There's also one point I want to share that my committee has unfortunately had to hear me share multiple times, like a broken record, but now I get to share it with all of you. The point that I want to make is that, in my opinion, it is rather strange and a bit dystopian to have a system in which our government can prosecute and punish its own citizens and then completely destroy the records and deny they ever existed. And so while I do find that strange, I also want to emphasize that there are significant benefits in allowing sealing when it comes to improving employment opportunities, increased salaries, removing stigma, and reducing recidivism. So with all that being said, I'm going to begin the walkthrough, which the bill starts on page 400 of today's calendar. So Section 1 amends the chapter adopted by the General Assembly in 2012 that sets forth the process for a person to petition to have a criminal history record sealed or expunged. Generally speaking, it moves in a direction of sealing for most cases rather than expungement. Expungement will still be available as part of deferred sentences, diversion, and for offenses that are no longer crimes. The change to 13 VSA 7601 lays out different definitions. The most substantive part of this section is the change to what is considered a qualifying crime. The qualifying crimes section describes what is eligible for sealing. So all misdemeanors are eligible for sealing or expungement, except for a list of exceptions located on page 402. The most important of those exceptions include listed offenses, which is a list of particularly serious crimes, most of which are felonies. The listed offenses are incorporated or are described in Title 13 VSA 5301. And some examples include domestic assault, murder, aggravated sexual assault, stalking, human trafficking, and a number of others. So to clarify, the crimes that I just described are offenses that cannot be sealed or expunged. There is also a new list of nonviolent property-related felonies that have been added to the list of qualifying offenses, meaning they can be sealed or expunged. These felonies were originally included in the governor's proposal, and speaking personally, I concur with the idea of allowing these offenses to be sealed or expunged. That list begins on page 403. The change to Title 13 VSA 7602 changed the process for a person to petition for expungement of a criminal history record if the offense is no longer a crime, or sealing of a criminal history record if it's a qualifying offense. The process is not available to an individual who is the holder of a commercial driver's license or commercial driver's permit seeking to seal a record of a conviction for an offense committed in a motor vehicle. The issue was a roadblock for making CDL operators because of federal law. So the changes also establish timelines and requirements for petitioning the court for offenses that are no longer prohibited by law. Subsection B, the petitioner must have previously completed any sentence or supervision for the offense and paid any restitution, and there is no waiting period. For qualifying misdemeanors, subsection C, at least 3 years have elapsed since the date on which the person completed the terms and conditions of the sentence. Any restitution and surcharges ordered by the court have been paid in full unless waived by the court, and the respondent has failed to show that sealing would be contrary to the interests of justice. For qualifying felony offenses, subsection D, at least 7 years have elapsed since the date on which the person completed the terms and conditions of the sentence. Any restitution and surcharges have been paid in full unless waived by the court, and the respondent has failed to show that the sealing would be contrary to the interests of justice. For a qualifying DUI misdemeanor, subsection E, at least 10 years have elapsed since the date on which the person completed the terms and conditions of the sentence. Any restitution and surcharges ordered by the court have been paid in full unless waived by the court, and the person is not the holder of a CDL, and the respondent has failed to show that sealing would be contrary to the interests of justice. The changes to Title 13 VSA 7603 affect some of the procedure for sealing and expungement when a person is acquitted. A record can be sealed within 60 days after the final disposition of a case if the court does not make a determination of probable cause at the time of arraignment, if the charge is dismissed before trial with or without prejudice, or the defendant is acquitted of the charge. The changes to Title 13 VSA 7607 modify the effect of sealing a record. While the effect of expungement remains the same, the effect of sealing has changed. except for certain circumstances where persons or entities are granted access to sealed records, a sealing order is effective immediately, and the person whose record is sealed is to be treated in all respects as if the person had never been arrested, convicted, or sentenced for the offense. The person who is the subject of the record and their attorney have access to use the records indefinitely, and other entities will be able to access sealed records for limited and specific purposes. And I'll note that in this section, in my opinion, it strikes a balance with some of the significant changes we've made. Specifically, we are creating stricter guidelines for how records can be accessed, thus providing greater protections for the confidentiality of those records. There's also a new civil penalty created that can be imposed against somebody who misuses sealed records. The entities and guidelines for accessing records are as follows. An entity or person may use sealed records in any litigation or claim arising out of the same incidents related to the record. A criminal justice agency or the Attorney General may apply to access a sealed criminal history record by filing a petition supported by a written affidavit filed with the court. The court shall grant access to the record upon a finding that reasonable suspicion exists that a sealed record contains information that will aid in criminal justice purposes. The current law allows criminal justice agencies to access these records essentially without restrictions, so long as they are used for criminal justice purposes. The next, a defense attorney may apply to access a sealed criminal history record by filing a petition supported by a written affidavit to the court. The court may grant access to the sealed record upon a finding that the sealed record may be of assistance to the attorney in representing the defendant. Currently, defense attorneys cannot access sealed records at all. Next, a law enforcement officer may access a sealed record under exigent circumstances. Exigent circumstances means a compelling need to act swiftly to prevent imminent danger to life or serious damage to property, to prevent the imminent destruction of evidence, or to prevent a suspect from fleeing. For alleged misuse of sealed records, a complaint may be filed with the Vermont Criminal Justice Council. A violation also shall be subject to the civil penalty provided in section 7611. There are a number of other changes, well, some of which were in previous law as well, but are much less impactful than what I've just described. That list is in the amendment in the calendar, and if anybody has questions, I'm happy to answer them. But moving forward, a party seeking to use a sealed criminal history record in a court proceeding must, prior to any use of the record in open court or in a public filing, notify the court of the party's intent to do so. The court will determine whether the record may be used prior to its disclosure in the proceeding. The changes to Title 13 VSA 7609 change expungement to sealing for persons aged 18 to 21 who commit a qualifying offense, and that can be petitioned within 30 days after any restitution and surcharges have been paid, unless waived by the court. The change to Title 13 VSA 7611 is essentially to add some teeth to the protection of confidentiality. That refers to the fine that I was describing earlier. It's a civil penalty of $1,000 if the records are misused. Section 2 allows for the expungement of municipal violation records after 2 years once judgment has been satisfied. This section is modeled after a similar provision enacted in 2021 regarding traffic violations and will apply to municipal violations that occur on or after July 1, 2024. Section 3 amends the previously adopted statute requiring expungement of traffic violations to clarify the implementation date. Section 4 provides the effective date of July 1, 2025. And I want to just conclude with the following points. There might be the question being asked of, why are we doing this after all? Ultimately, these changes address a range of issues from government transparency and accountability, rehabilitation and reintegration into local communities and workforce, public safety, and streamlining what was previously a very convoluted process. So previously it was very convoluted. Now it's, I would describe it as just moderately convoluted. We heard from the following witnesses, the president of the Vermont Sheriff's Association, the racial justice data analyst from the Division of Racial Justice Statistics, legislative counsel, DCF, the Attorney General, court administrator of the Vermont Judiciary, the president of the Vermont Bankers Association, the executive director of the Office of Racial Equity, the operations director from the Family Services Division, Department of DCF, the director of the Adult Protective Services Division from the Department of Disabilities, general counsel from the Department of Public Safety, the director of research from the Crime Research Group, the executive director and general counsel from the Department of States Attorneys and Sheriffs, general counsel from DCF, Defender General and the Deputy Defender General, the Deputy Commissioner from the Department of Motor Vehicles, the Director from the Vermont Crime Information Center, the Director from the Crime Research Group, and the Chief Superior Judge of the Vermont Judiciary. The vote in committee was 4-1-0, and I ask for the Senate's support.
I now recognize the senator from Chittenden North for the report of the Committee on Finance. Senator Matos.
Thank you, Mr. President. Your Finance Committee looked at this bill specifically in subsection 7610, Criminal History Record Sealing Special Fund, where any fees would be deposited to for sealing of the record. The fund was created several years ago, about 2019. It has about $26,000 in it, and what we uncovered was how many fees are being charged for sealing and how many offenses are being charged. And it might be one, it might be none, it might be many. So we felt as a committee it'd be best looked at in the Judiciary Committee. And I have spoken with the chair of House Judiciary, made him informed of our thoughts on the bill to be able to look at those fees. Should it be for all of these sealings? Should there be a fee? Is it just the one that's currently in law? So I've made our point known to the House and the Judiciary Committee to look further on that. And just a little background on that, I also serve on the Judiciary Committee in the morning here in the Senate. We were so involved in the policy making of this bill that the fees weren't looked at too heavily by us. So we wanted to make sure that there were some eyes in the Judiciary Committee in the House to be able to look further into this. And on a 7-0-0 vote, we ask for your support. Thank you.
The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Committee on Judiciary. The question is now, shall the bill be read a third time? Are you ready for the question? Senator from Chittenden.
Thank you, Mr. President. All senators know that on your committees, there are things that you put out that everyone in the building regards as a big achievement. And then there are things that only people on your committee know are big achievements. This is a big achievement, and I wanted to credit our chair with that. So the history of this is that going back under Senator Sears, the Judiciary Committee was interested in various sides of criminal reform, criminal justice reform, corrections reform. One of the pieces of that was expungement, and the idea that we should be allowing people to go forward into the working world after they had served their time or made amends with the judicial system, the justice system, and they shouldn't be punished going forward. So expunging their record allows them to do that because it doesn't exist. With sealing, a record still exists. So in current law, there are major areas where expungement is a possibility, but we found out after that had gone into law that it produced this double track of expungement and sealing, produced a huge workload for the agencies and officials involved. And so going back about 5 years ago or 6 years ago, there was an attempt to get to single track. And that effort crashed and burned 4 or 5 times with Senator Sears trying his best to work out an agreement. The missing piece was what we were able to get this year, and that is on page 414, the idea that a court will mediate these requests. So sealed records are still sealed. If anybody tries to get a hold of them who shouldn't, they would receive a message saying that they can't access a record or none exists. But in the event that it's necessary in court for a law enforcement agent or a state's attorney really has actionable reasons to get that information, a court can access it. So again, that was the missing piece that has allowed us to move effectively to a single track to get the benefits of this sort of reform without the attendant consequences of increasing amazingly people's workload. And just to give you a sense of that, when you expunge somebody's record, that means you have to destroy all the records along the way, including testimony in court, evidence, different case files that might look like this. Someone has to go through by hand and actually erase them. So under this system, they're sealed. You don't have to destroy them, but there is court-dictated access to them. So again, just my congratulations to the chair. I think Senator Sears would be very proud.
Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it. And you have ordered third reading of S12. We now have S56, introduced on February 7th of 2025. And it was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that the bill be amended as set forth in the calendar today on page 420, and that when so amended, the bill ought to pass. It was then referred to the Committee on Appropriations, which reports it has considered the bill and recommends that the bill ought to pass when amended as recommended by the Committee on Government Operations. Please listen to the second reading of the bill.
S56, an act relating to creating an office of New Americans.
I recognize the senator from Chittenden Central, Senator Lehofsky, for the Committee on Government Operations.
Thank you, Mr. President. S56 is a really great bill. It is a workforce development bill. It is a support bill. It is a bill that will grow our economy, and we heard overwhelming support for this bill. What S56 does is it creates a study committee to begin us on the path of creating the Office of New Americans. It directs, there are 8 members of this study committee. The committee shall be composed of the director of the Vermont Refugee Office. This individual currently does excellent work with refugees and asylum seekers here in Vermont. And what we heard from her is there is a scope of work outside what she is able to do that needs to be done to continue supporting new American members in our in Vermont. And so this office would not eliminate the work she does. It would be an expansion of the work she does to incorporate all the things that she says she can't do but wishes she could to support our new American community members. The director of the Vermont Refugee Office will be the chair of the committee. It will also contain 1 member appointed by the Commissioner of Labor, 1 member appointed by the Executive Director of the Office of Racial Equity, and 5 members to be appointed by the governor, one of whom must be a new American with lived experience in Vermont. 1 member will be nominated by the Association of Africans Living in Vermont, 1 member by the United States Committee for Refugees and Immigrants, 1 member nominated by the Vermont Afghan Alliance, 1 member nominated by the Brattleboro Development Credit Corporation, and I know this is weird, but I'll explain it in a minute, and 1 member nominated by Migrant Justice. Initially, as the bill came to us, it was a much larger committee, and it included members from the Brattleboro Credit Corporation and members from the World Education Service. The World Education Service is a nationwide group that has set up these offices of New Americans all across the country. More than half of the Vermont states do have this office in existence now. What we initially, as we were paring down this list, we put the World Education Services and took off the Brattleboro Credit Corporation. But what we then heard is they are actually our local entity that is doing the work with World Education Services, and so they made more sense to be on this to help bring the expertise from the nationwide entity, but in a grounded in Vermont way. What we heard is that new Americans and immigrants are incredibly likely to start businesses, but they grapple with navigating some of our complex systems, that they add to our economy and they add to the vibrancy of our communities, but due to some of the challenging bureaucratic systems, they sometimes need support navigating them, and this office would be set up to help them do that, set up to help them get licensed as teachers and nurses, set up to help them open small businesses and really be full, welcomed members of our society. We have tasked this study committee to look at a summary of who is in Vermont and who is coming to Vermont, and to advise us on how to best set up this office in Vermont, as well as to provide us a Vermont-based definition of what is a new American. We found the testimony in committee incredibly compelling, that this is the right way for us to invest in Vermont. And the vote in your government, actually, I'll tell you who we heard from. We heard from Tucker Anderson from Legislative Council, Alex Beck, who is the Welcoming Communities Manager at the Southern Vermont Working Communities Challenge, Tim Devlin, Legislative Council, Tracy Dolan, who is the Director of the State Refugee Office and will be the chair of the study group. We heard from Senator Gulick, who is the sponsor of the bill, Lauren Hibbert, the Deputy Secretary of State. We have tasked the commission to consult with the Secretary of State, as their office touches the new American experience in many different ways. And they were very happy not to be a named member of the study committee, but the consultant instead. We heard from Ruth Steinmetz, the initiative director at the Winooski Working Communities Challenge, and Mike Zimmer, who's the senior policy consultant at the Office of New Americans State Network. Your Government Operations Committee voted 5-0-0 in support of this moving forward, and we ask for the Senate's support.
I now recognize the senator from Lamoille, Senator Westman, for the report of the Committee on Appropriations.
The Appropriations Committee reviewed S56. The underlying original bill as introduced had legislators on. The legislators were removed before it came to our committee. The only section in this that that's left related to that is a section in section 1, H1, where it says if there are legislators that end up being appointed, that in the off section they could get paid, but there are no out-and-out legislators on this committee now. We supported the bill 7-0-0.
The question is, shall the Senate amend the bill as recommended by the Committee on Government Operations? Are you ready for the question? Senator from Essex.
Thank you, Mr. President. Can I inquire of the presenter of the bill, please?
Presenter is interrogated.
Mr. President, I didn't hear, and if I did, I apologize, what the definition of a new American is.
We have actually tasked this study committee to provide us that definition.
And as far as, Mr. President, as far as what we already have set up in the state of Vermont, as far as to help refugees come in and do the same thing, how does this differ than what we already have set up, Mr. President?
We heard testimony from the director of the Vermont Refugee Office that there is a wide-ranging scope of work that is not under the purview of her office that is supportive of new Americans, and this is meant to alleviate that challenge.
Mr. President, did they spend any time adjusting the current programs of what we have already in statute or in existence to maybe, instead of spending monies to develop a brand new program, just expand on what is already there?
What we heard is that this is necessary, as what is currently in existence is not able to meet the need. And this is a study committee to tell us exactly what that would look like.
Mr. President, did we take any testimony on that was what we could do differently?
What we heard from the director of the Vermont Refugee Office is her office is not able to fully meet the need, and they are supportive of moving in the direction of creating a larger scope, an office with a larger scope that would include the work that they do as well as the work that they are unable to do. And they are very supportive of this study committee to move us in that direction.
And Mr. President, what was the expected expense? I know appropriation strips out money, but what was the expense that was going to be thought to set the study group up?
If I recall, there was a fiscal note, but I will, if certainly allow the senator from Lamoille to correct me if my memory is wrong, but I believe the expected cost was about $6,000.
Thank you, Mr. President.
Are you ready for the question? The question is, shall the bill be amended as recommended by the Committee on Government Operations? Are you ready for the question? If so, all in favor say aye. Aye. All opposed say nay. The ayes have it, and you have amended the bill as recommended by the Committee on Government Operations. The question now is, shall the bill be read a third time? Are you ready for the question? Are you ready for the question? If so, all in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S56. We now have S63 on the calendar for action, introduced February 11th, 2025. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the bill be amended as set forth in today's calendar on page 423, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Finance, which reports it has considered the bill and recommends that the bill ought to pass when amended as recommended by the Committee on Health and Welfare. Listen to the second reading of the bill.
S63, an act relating to modifying the regulatory duties of the Green Mountain Care Board.
Recognize the senator from Orleans, Senator Douglas, for the report of the Committee on Health and Welfare.
Thank you, Mr. President. Unfortunately, I do not have any haikus for the Senate, but this is it's a housekeeping bill. It's the best way I can describe it. Fixes redundancies and adjusts the language to a shifting healthcare landscape as the system moves away from the all-payer model of payment to a future system, perhaps the HEAD model. And I will go section by section for the Senate. And I will preface this by saying that these changes were requested by the Green Mountain Care Board, and we heard from a number of their staff and of their members coming in and testifying on it. So section 1 eliminates the Green Mountain Care Board's duty to review and approve the statewide health information technology plan. Section 2. This has to do with VITAL, Vermont Information Technology Leaders, and I'll define that very briefly. VITAL is a data aggregate. They take in data information, clinical claims data from providers and from patients, and then they provide that data in a more condensed form for insurance companies and for providers. So they aggregate data. And it eliminates, section 2 eliminates the Green Mountain Care Board's duty to approve VITAL's budget annually. VITAL is, according to the Green Mountain Care Board, VITAL is no longer in a financial position to need that review. So Green Mountain Care Board would like that removed from their list of duties. It also eliminates VITAL's duty to provide criteria to the Green Mountain Care Board annually regarding healthcare providers' connectivity to the state health information exchange network. They think connectivity review is VITAL's purview, and they don't want to step on the toes of VITAL. So Green Mountain Care Board, again, would like this removed from their duties because they don't think it's their scope anymore. Section 3, this is the Green Mountain Care Board Bill Back formula. It modifies the Bill Back formula, which is the formula that allocates many of the Care Board's expenses between the state and the entities that are regulated by it on a 40-60 split. So it eliminates the 8% allocation for accountable care organizations, or ACOs, and increases the allocations for hospitals and for health insurers. And the state's allocation remains the same number. So the state isn't paying any more money. It's coming from the hospitals and the insurers to make up for that 8% that's being taken away from accountable care organizations. That's due to accountable care organizations no longer really being within the state, the state healthcare plan going forward. We are losing the only accountable care organization that we have in the state right now, which is in Chittenden County, the One Care Center. So we're losing that. So we're taking away the 8% allocation from ACOs because we're losing our ACOs, and it's not really going to be a big step in Vermont healthcare going forward. So Section 4 is more eliminations from the Green Mountain Care Board's duties. I know the Green Mountain Care Board has been in the news a lot frequently, and I'm sure a lot of Vermonters, especially up in my area, will be happy they're removing some of the duties. So the list of duties that they're eliminating is the review and approval of the statewide health information technology plan. They view that the HIT plan as a collaborative process, and a review of that plan kind of feels more like oversight. Like they're the ones that are doing the plan. So they want to put that back into the hands of the HIT itself. So they also want to eliminate the duty of the Green Mountain Care Board to review and approve criteria for healthcare providers' connectivity to the state health information exchange network. The review and approval of Vital's budget, which again, I think that goes back to the stepping on toes. They want to eliminate the duty of the Green Mountain Care Board to review mental health and substance abuse treatment data that used to be reported to the Department of Financial Regulation under a statutory provision that was repealed in 2015. So there's some redundancies that we're removing. Section 5. So this is more about the ACOs, the oversight of accountable care organizations. It expands the scope of ACOs that must be certified in order to operate in Vermont from those that receive payments from Medicaid and or commercial insurance through payment reform program or initiative to any ACO. So there's been a collaborative process for a number of years that is trying to get the ACOs to a single one-time certification that can then be annually done instead of having multiple different certification processes. And it modifies and simplifies the criteria that must be met for the Green Mountain Care Board to certify an ACO. It allows the Green Mountain Care Board to adopt rules, creating a streamlined certification process for Medicare-only ACOs, eliminates existing ACO budget review provisions, and establishes new budget review criteria for ACOs that accept Medicaid and commercial insurance or commercial insurance, but not Medicaid payments. It establishes the following ACO fees: $10,000 for initial certification, $2,000 for renewal certification, and $125,000 for budget review. So, and that's an initial review of their budget. Pretty good. Moving right along to section 6 and 7. Section 7 is where we're making an amendment from the committee after we received feedback from VAHS, which is the Vermont Association of Hospitals and Health Systems. So section 6 and 7 revises hospital budget review provisions to allow a psychiatric hospital that is not operated by the state to have a fiscal year that runs January 1st, December 31st. There's a technical change. All other hospitals will continue to have a financial year that runs October 1st to September 30th. So that change in the fiscal year only affects psychiatric hospitals not run by the state. It does not affect our current hospitals. Senate Health and Welfare proposed an amendment that excludes additional changes to section 7 from the bill as introduced, and you will have that in today's calendar. Section 8 refers to the meetings of an accountable care organization's governing body. It updates the statutes on their meetings. Again, more of a technical change. Section 9, this is a repeal section, so it repeals a statute requiring the Green Mountain Care Board to conduct an advisory annual review of any all-inclusive population-based payment arrangements between the Department of Vermont Health Access, or DVA, and an ACO for the following calendar year. And that's due to the winding down of the One Care that's in Vermont at the end of 2025. So section 10 is your effective dates. Section 6 and 7 are hospital fiscal years for budget purposes. That section will take effect on passage, and the remaining sections take effect on January 1st, 2025. I will read the list of witnesses. So in Senate Health and Welfare, we heard from Jennifer Carby, the Office of Legislative Counsel. We heard from our very own Senator Virginia Lyons, the sponsor of the bill. We heard from Michael Barber, the General Counsel of the Green Mountain Care Board. We heard from Diane Lamfer, the Director of Legislative Affairs for the Green Mountain Care Board. We heard from Michelle Sawyer, Health Policy Project Director for the Green Mountain Care Board. While they did not testify, we also did hear from Vermont Medical Society and also from VAHS, again, the Vermont Association of Hospitals and Health Systems, that they are neutral about this bill, neutral/positive. I welcome any questions. Thank you, Mr. President.
I now recognize the senator from Chittenden Central, Senator Gulick, for the report of the Committee on Finance.
Mr. President, the Committee on Finance looked at S63. We heard from Legislative Counsel and the Joint Fiscal Office. We found the fees to be appropriate, and we voted favorably S63 out of committee on a 7-0-0 vote. Thank you.
The question is, shall the Senate amend the bill as recommended by the Committee on Government Operations? Senator from Orleans.
I apologize to the Senate. The vote in Health and Welfare was 5-0-0.
The question is, shall the Senate amend the bill as recommended by the Committee on Government Operations? Am I in the right? On Health and Welfare. Are you ready for the question? And Senator from Wyndham.
Thank you, Mr. President. I had one, maybe a few questions. If I may interrogate the reporter for the bill.
Presenter of the bill is interrogated.
Thank you. I'm just looking at page 423 regarding the budget review for psychiatric hospitals. Wyndham County has the Brattleboro Retreat, a rather large psychiatric hospital that's not owned or operated by the state. Were psychiatric hospitals previously, were they previously required to go through this process with the Green Mountain Care Board?
Mr. President, I cannot answer that question directly, but I can speculate that they probably were not. I will yield potentially to the chair of my committee to answer that question.
Would the chair of the committee like to be yielded to? Answer the question. Okay.
President. I think we will come back with this more specifically on third reading. Suggestion that we do have public dollars going to the psychiatric hospital, and the budget review in that case is important. So, but we will clarify for third reading. Thank you.
Thank you.
Are you ready for the question? The question is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? If so, all in favor say aye.
Aye.
All those opposed, nay. The ayes have it, and we have amended the bill as recommended by the Committee on Health and Welfare. The question now is, where am I? Oh, we are down there. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye.
Aye.
All those opposed, nay. The ayes have it, and you have ordered third reading of S63. You have Senate Bill 126 for second reading. An
Mr.
act.
President, I've asked to have that passed over until next week. Thank you.
We will pass over S 126. We now have S 36, an act relating to Medicaid coverage of long-term residential treatment for co-occurring substance use disorder and mental health conditions. It was introduced January 30th of 2025, and it was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the bill be amended as set forth in today's calendar, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Appropriations, which recommends that the bill ought to pass when amended as recommended by the Committee on Health and Welfare. Listen to the second reading of the bill.
S 36, an act relating to Medicaid coverage of long-term residential treatment for co-occurring substance use disorder and mental health condition.
I recognize the Senator from Orange, Senator Hart, for the report of the Committee on Health and Welfare.
Mr. President, we have an amendment to the bill in Section 133 VSA 19019 Senator Lyons had requested that before we use the word high intensity, we put medical necessary in front of it. And in section 2, VSA 19010 or O, the same phrase, medical necessary, would be in front of low intensity. And in both instances where it appears. Okay. And I have a section 1 adds VSA 1901N, high intensity residential treatment for substance use disorder and co-occurring mental conditions, excuse me. A, requires Agency of Human Services to provide coverage for medical necessary high intensity medical monitored residential treatment episodes to Medicaid beneficiaries with SUDs and a co-occurring mental health condition when high-intensity medical monitored resident treatment episodes are prescribed by a health care professional employed by a residential treatment program who is practicing within the scope of the health care professional's license. And the residential treatment program is participating in the Vermont Medicaid program. B, requires that the coverage provided under this section is for the entire length of stay prescribed by a health care professional employed by a residential treatment program, and that the health care professional take into account best practices for each level of care within the substance use containment of care. Section 2 adds 33 VSA 19010, low intensity residential treatment for substance use disorder or co-occurring mental conditions. A, requires Agency of Human Service to provide coverage for medical necessary, low intensity, clinical managed residential treatment episodes to Medicaid beneficiaries with SUD and co-occurring mental health condition when low-intensity clinical managed residential treatment episodes are prescribed by a health care professional employed by a residential treatment program who is practicing within the scope of the health care professional's license, and the residential treatment program is participating in the Vermont Medicaid program. B, requires that the coverage provided under this section is for the entire length of stay prescribed by a health care professional employed by a residential treatment program, and that the health care professional take into account best practices for each level of care within the substance use continuum of care. Section 3, report. Medicaid payment models for residential substance use disorder treatment services requires Agency of Human Services to conduct a review of the Medicaid payment model for residential SUDs treatment services with the consideration given to the actual cost of providing residential treatment services, co-occurring physical and mental health needs, and post-residential treatment services needed. The review shall contain recommendations and proposed legislation on aligning the Medicaid payment model with clinical needs of individuals receiving residential substance use disorder treatments and services, ensuring the coordinated transition between the substance use disorder treatment providers offering varying acute of care. Agency of Human Service shall submit results of this review to SHW and HHS by 12/1/25. Sections 4 and 5 repeal provisions that have yet to take effect that would have prohibited public inebriates to being incarcerated in the DOC facility. The effective date is July 1st of 2025. In our committee, we took witnesses on S36 from Kelly Daughtry, Deputy Commissioner for Vermont Department of Health, Tony Folan, Clinical Service Manager and State Opioid Treatment Authority through the Vermont Department of Health, Candace Gale, Director of Community Relations, Vermont Foundation of Recovery. The sponsor of our bill, Senator Virginia Jenny Lyons, Alex McCracken, Director of Communications and Legislative Affairs in the Department of Vermont Health Access, Katie McClynn, Legislative Counsel, Office of Legislative Counsel, Monica Ogilvie, Medicaid Director, Agency of Human Services, Mark Redmond, Executive Director of Spectrum Youth and Family Services, Jenny Samuelson, Secretary, the Agency of Human Services, Chris Smith, Chief Clinical Officer, Spectrum Youth and Family Services, Don Tatro, Founder and Director of Janus Promise. And the last would be Chad Vigor, Executive Director of the Recovery House Incorporated in the state of Vermont. Thank you, Mr. President.
I now recognize the senator from Chittenden Southeast, Senator Lyons, for the report of the Committee on Appropriations.
Thank you, Mr. President. Appropriations reviewed the bill and understand that, I'll just explain briefly, the senator from our Health and Welfare Committee also included in his report an amendment that I will be proposing before third reading. And this amendment came to the Health and Welfare Committee after the bill was voted out, and so was also considered within Appropriations. Appropriations feels that the amendment is better offered before third reading. But given that proposal that will be made and the report that you've heard, Appropriations approves bill and as written, and there are limited or zero costs. It's budget neutral for the proposal. So, thank you, Mr. President.
Mr. President, my apologies to the Senate. I did not vote. I did not tell them to vote.
Senator, you need to be recognized before you start speaking. So if you stand up, I will say Senator from Oregon.
Okay, sorry.
Go ahead, Senator from Oregon.
My apologies. I didn't, at my final conclusion, I did not say that Health and Welfare voted this through at 5-0-0. So my apologies to the Senate for not doing it.
The question is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare? Senator from Windsor.
Thank you, Mr. President. May I interrogate the reporter of the bill?
The reporter of the bill is interrogated.
I'm so grateful that this bill has come to the floor. As someone who's in the recovery space, I appreciate and I believe the intent of this bill is to expand coverage specifically for our lowest income Vermonters. And I just have one question, which is, do low-intensity residential treatment facilities that are out of our state also participate in the Vermont Medicaid? Are they approved under Vermont Medicaid? So if I'm a resident in White River Junction who would be eligible for this expansion, can I go to a facility that's out of state, like New Hampshire?
Mr. President, may I refer that to our committee chair?
The senator yields to the senator from Chittenden Southeast.
Thank you, Mr. President. I'm not aware that the Granite program that's in New Hampshire that may receive residents from Vermont also are Medicaid reimbursed. We do have a relationship with one larger hospital in Vermont. We can clarify if there are agreements outside of the state or if Medicaid patients have the dollars follow them before third reading. Thank you.
Thank you. I would appreciate that. And I'll just conclude by saying I do hope that this bill would include out-of-state potentially providers, if that's
able to happen with Medicaid dollars, because on our side of the river, there are fewer opportunities for folks to have residential treatment. And unfortunately, it seems like if there's not a bed, even if you're in a situation where you need a bed, you don't get one. And that's really unfortunate when there are families who are in crisis or individuals who would benefit from inpatient stay. So I appreciate that. I had one other question, and I guess I would interrogate the reporter of the bill again.
Senator from Orange is interrogated.
How does this affect outpatient services? This specifically seemed to address inpatient services for recovery treatment facilities. If I wanted to participate in a program where I wasn't residing in the facility, would I also now have Medicaid expanded to cover that? Or is it only if I'm residing in the provided, in the location?
The senator from Orange yields to the senator from Chittenden Southeast.
Thank you, Mr. President. This is a really terrific question. And just to step back to the previous question, one of the goals of the study is to actually continue an evaluation of what New Hampshire is doing through the Granite State program, because it is a little more coordinated as a system than ours is in this state, and that's one of the goals that we have. To answer your question regarding outpatient, no, this, the bill, and especially as the amendment will propose, is to look at the medically necessary, so it's medical treatment. It isn't, it is the shorter term treatment that is needed for folks in a facility. It does not extend to the full recovery time, which is more of the low intensity. However, if there are medically necessary treatments during lower intensity recovery, and it is residential, then that would apply. So the answer is it doesn't extend, it's not everything, and which is why the study is included in the bill. But so it's an excellent question, and it's the type of answer we're trying to get to as we continue to work on recovery programs and recovery centers. So thank you.
I thank the chair of the committee for her remarks, and I appreciate that. I think something that comes up quite a bit in the recovery space is there's not a one-size-fits-all model for what works for Vermonters. And if you recently saw the 7 Days article that discussed how Vermont has a substantial drinking problem, our relationship to alcohol and substance misuse disorder is a growing challenge. I do hope that if there is Medicaid expansion, in the future, that we are able to expand it for coverage for outpatient, because primarily in my experience, the folks that choose outpatient is because they can't leave a job, a family member, a workplace to actually go into a residential facility, because leaving that life would basically crumble their ability to go back to it. So I do hope in the future with this study that we look at outpatient opportunities for Medicaid. So thank you, and I look forward to hearing on third reading what the Granite State work we can partner on is.
Are you ready for the question? The question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for the question? If so, all in favor say aye. Aye. All those opposed, nay. The ayes have it. You've amended the bill as recommended by the Committee on Health and Welfare. Now the question is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S-36. We now have on the calendar for action S-53, introduced on February 6, 2025. The bill was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that the bill ought to pass. The bill was then committed to the Committee on Health and Welfare, which reports that it has considered the bill and recommends that the bill be amended as set forth in today's calendar. The bill was then referred to the Committee on Finance, which reports that it has considered the bill and that the bill ought to pass when amended as recommended by the Committee on Health and Welfare. The bill was then referred to the Committee on Appropriations, which reports that the bill that it has considered the bill and that the bill ought to pass as introduced without the recommendation of amendment by the Committee on Health and Welfare. Please listen to the second reading of the bill.
S53, an act relating to certification of community-based perinatal doulas and Medicaid coverage for doula services.
Recognize the senator from Rutland District, Senator Collmore, for the Committee on Government Operations.
Thank you, Mr. President. Again, the Government Operations Committee took a look at this bill strictly through the lens of certification. S53 establishes a voluntary certification process for community-based perinatal doulas in Vermont during labor, birth, and the prenatal and postpartum periods. It introduces a new chapter in Title 26 that defines key terms related to community-based perinatal doulas. It outlines the duties of the Director of the Office of Professional Regulation, sets forth eligibility requirements for certification. The bill also includes provisions for penalties related to the misuse of certification titles and establishes a fee structure for applications and renewals specific to community-based perinatal doulas. The Office of Professional Regulation testified they recommend certification of community-based perinatal doulas who provide non-clinical and non-medical support. OPR has determined that certification is the least restrictive form of regulation necessary to protect the public. Certification is a voluntary credential that requires the practitioner to have achieved specific competencies through training, mentorship, and/or education. The committee heard from Deputy Chief Counsel, the Office of Legislative Counsel, the Deputy Secretary of State, the lead sponsor, the senator from Chittenden Central, and a doula and advocate from the Washington County Mental Health Services, and by a vote of 4-0-0, recommend that the bill pass. Thank you, Mr. President.
I now Senator from Rutland, would you like to correct your vote?
I thought I said 5-0-0.
5-0-0 we'll take.
Thank you, Mr. President.
Oh, we said, oh.
I now recognize the senator from Chittenden Central District, Senator Gulick, for the Committee on Health and Welfare.
Thank you, Mr. President. I was prepared to speak to the underlying bill, but my colleague from Rutland, Senator Collmore, did such a lovely job that I will just present you with the amendment from the Senate Health and Welfare Committee. Our amendment really adds effective dates and an appropriation. We added a Section 8 appropriating $25,000 to OPR in fiscal year 2026 to establish the certification program for community-based doulas. And Section 9, Sections 1 through 4, establishing a certification program for community-based doulas takes effect on July 1st, 2026, with rulemaking happening earlier to ensure rules will be in place on the date. Senate Health and Welfare amendment adds Section 8, as I said, OPR appropriation to this July 1st, 2026 effective date of the state plan Section 5 of 33 VSA 1901N, Medicaid coverage takes effect on later of July 1st, 2026, or approval of the state plan amendment if once it's needed. The remaining sections take effect on passage. I hope that was clear. Thank you, Mr. President. And we voted it out 5-0-0. We heard from Legislative Counsel, the Joint Fiscal Office, the Office of Professional Regulation, OPR, DEVA, the Department of Health Access, as well as a doula and an advocate in Washington County Mental Health Services, Maria Rossi. Thank you very much.
Now, I believe I recognize the senator from Chittenden Central, District again, Senator Gulick, for the report of the Committee on Finance.
Yes, that is correct. The Committee on Finance looked at the fees associated with this bill, S53, and we found the fees to be reasonable, and we passed this bill out of committee 700. Thank you, Mr. President.
I now recognize the Senator from Washington District, Senator Perchlik, for the Committee on Appropriations.
Thank you, Mr. President. Your Committee on Appropriation reviewed this bill for any appropriations or impact on the revenues of the state. And looking at the bill as introduced, as you'll have on your desk, there are no appropriations. But we knew that the amendment from the Committee on Health and Welfare was going to include an appropriations. So the way this is worded, we were going to amend the bill to take out the appropriation, but the appropriation hasn't been made yet because we haven't accepted that amendment. So the Committee on Appropriation recommends that the bill ought to pass favorably, but with the amendment that's going to be proposed by Health and Welfare to be voted down. So we're voting for the bill, but asking you not to vote for the amendment that the Committee on Health and Welfare is presenting, if that's clear. And we voted on that 6-0-1.
Because the report of the Committee on Government Operations and Appropriations are favorable, there is only one report to vote on, and that is the Committee on Health and Welfare. Therefore, the first question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for the question? Senator from Madison.
Thank you. I'm confused.
Not ready for the question?
I'm not ready for the question. The senator, may I inquire of the senator from Appropriations?
The senator from Washington is interrogated.
Could you repeat what your recommendation is?
Yeah, sorry, Mr. President, that I was not clear in that. It was a little confusing even when I saw the way it's worded in the calendar than the way we talked about it in the committee. But normally we would pull out the appropriation. The appropriation wasn't in there, so we couldn't pull it out. So we're basically saying our favorable report of the bill is contingent on the amendment that puts an appropriation in not passing. If the amendment from Health and Welfare was to pass to include a $25,000 appropriation, I would think that the Appropriations Committee would make an amendment on third reading to take it out.
Okay, so the Appropriations Committee is recommending that we reject the Health and Welfare Committee's report?
That's right, Mr. President, but vote for the bill.
Okay, thank you. May I inquire of the Chair of Health and Welfare, please?
The Chair of Health and Welfare is interrogated.
Thank you, Mr. President. Is the Health and Welfare Committee okay with this recommendation from Appropriations?
Yeah, Mr. President, we did not review the appropriations proposal of amendment. We don't usually do that with regard to recommendations on funding. So, Mr. President, this leaves the $25,000 appropriation for the Office of Professional Regulation to put in place a certification program in our proposal of amendment. And the Appropriations Committee is recommending that it come out. So you have heard from both committees, but we do not take testimony on the appropriations recommendations.
Okay, so Mr. President, if you could stay standing, I have a follow-up question for the Chair of Health and Welfare. So I hear that the committee didn't take testimony on this, but you are on both committees, and I'm wondering what your recommendation is.
Well, as a member of Appropriations, I voted for the appropriations recommendation. So I am now split down the middle.
I feel ya. All right, thank you, Mr. President.
Senator from Chittenden.
Mr. President, if I might, I think this presents as overly complex, but as the Chair of Appropriations said, if the Health and Welfare Amendment were to pass, Appropriations would bring an amendment to remove it on third reading, which I also believe would pass. So I think it saves everybody a step to vote down the amendment from the Health and Welfare Committee with great appreciation for their work.
Senator from Chittenden.
If it might be helpful, the way I'm seeing this is that I will say yes to this bill from government operations, I will say no to this bill from health and welfare, and then I will say yes to this bill from appropriations. Thank you, Mr. President.
Are you ready for the question?
Point of inquiry, Mr. President. I think your original motion has us going straight to the.
The question
Health and
is, would you
welfare.
like me to state the question?
Yes, please state the question.
The question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for the question? If so, all in favor say aye. All those opposed, nay. Nay. The nays have it, and the amendment from Health and Welfare failed. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of S53. I believe we are now going to take up confirmations. The senator from Rutland, Senator Collmore.
Thank you, Mr. President. I move that the rules be suspended and that all gubernatorial appointees who appear in today's calendar, whose names are not underlined, and I believe there are 2, be taken up together and without debate.
The senator from Rutland has moved that the rules be suspended and that all gubernatorial appointees who appear in today's calendar, whose names are not underlined, be taken up together and without debate, and that they be confirmed by the Senate. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we have taken them all up and confirmed them by the Senate. Oh, more confirmations. Okay. Okay, and now we have appointments reported out of committees to take up for confirmation. We have first, Anson Tebbets. The appointment is of Anson Tebbets for Secretary of Agriculture for a term from and including March 1st, 2025 to and including February 28th, 2027, and until a successor has been appointed and is qualified. The senator from Rutland.
Thank you, Mr. President. Anson Tebbets was appointed by Governor Phil Scott to be the Secretary of Agriculture, Food and Markets in 2016. Anson grew up on his dairy farm in Cabot, where his family raised Jersey dairy cows, sheep, and ran a Vermont maple syrup sugaring operation. While farming, Anson also had a long career in broadcasting, in both radio and television, an award-winning reporter and storyteller. Anson's last position was managing reporters, editors, and photographers for television. He was the news director for WCAX-TV. Still lives in Cabot on his family farm. His son Alden, a student at Middlebury College, hunts wild turkey and deer. His wife Vicki enjoys foraging the land, and his daughter Adelie, also a student at Middlebury College, loves the forest and baking. As the Secretary of the Agency of Agriculture, he manages a staff of 130 people, balancing competing priorities, mediating difficult issues, and managing multi-million-dollar budgets. He established the Northeast Dairy Innovation Center with Senator Leahy back in 2020. As I mentioned, a winner of several Associated Press awards. What you may not know about Secretary Tebbets, he was the prom king at Cabot High School in 1982. Committee met with the secretary and found him eager to continue his work as the secretary, and by a vote of 5-0-0, recommend he be reappointed. Thank you.
The question is, shall the appointment of Anson Tebbets as Secretary of the Agency of Agriculture be confirmed by the Senate? Are you ready for the question?
Roll call.
Roll call has been asked for. Are you ready for the question? The Secretary may call the roll.
Senator Baru.
Yes.
Senator Beck.
Yes.
Senator Bongard.
Yes.
Senator Brennan. Senator Brock.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Douglas.
Yes.
Senator Ewing.
Yes.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hart.
Yes.
Senator Hashi.
Yes.
Senator Heffernan.
Yay.
Senator Engel.
Yes.
Senator Lyons.
Yes.
Senator Major.
Yes.
Senator Matos.
Yes.
Senator Norris.
Yes.
Senator Pershling. Yes. Senator Funky.
Yes.
Senator Mom Hinsdale.
Yes.
Senator Behovsky.
Yes.
Senator Watson.
Yes.
Senator Weiss.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Senator Williams.
Yes.
Senator Brennan.
The ayes are 29, noes are 0, and you have confirmed Anson Tebbetts as the Secretary of Agriculture. Hi, we now have William Scholdice. William Scholdice, Commissioner of Tax for a term and including March 1, 2025 to and including February 28, 2027, and until a successor is appointed and has qualified. For the report, we go to the senator from Washington, Senator Cummings.
Thank you, Mr. President. I apologize, I don't have my cheat sheet, so we can either pass this over or you're going to have to rely on the wisdom of the Finance Committee and my memory. I will start, but any lacks are not the fault of the candidate. William Scholdice is a native of Montpelier. His family is well known in this body. His father was a long-time lobbyist, and his sister has taken over that job. He has a long history in the private business sector. He started out being the Deputy Commissioner of Commerce under, I think it might have been Governor Dean, I could be mistaken. Went in then to the private sector, came back, his most recent job was heading the Vermont Teddy Bear Company, which is something I know something about, and it has survived. And there was a boom in the 80s and 90s in teddy bear interest, and not everyone has survived. So it is a credit that it has. He is now back in the public sector. He is a resident of Stowe. We interviewed him. He came in his first week and was kind of interviewed and got to know the joint meeting between the House Health and Ways and Means and the Senate Finance Committee. We asked him any questions. He's really in a learning phase at this point, is very impressed, as are we, as the very high ratings of employee just morale within the tax department, which those of us who've been around know was not the case in recent history. He's determined to do that. He's very committed to customer service and making sure that the tax department maintains its high level of customer service. He said the first thing he asked about was employee morale, and the second thing was, how's your technology? And he has found that both of those are high standard, so he's feeling very confident. And your Finance Committee recommends his approval on a vote of 7-0-0.
The question is, shall the appointment of William Scholdice be confirmed by the Senate? Are you ready for the question?
Roll call.
Roll call has been requested. The secretary shall take the roll.
Senator Baru.
Yes.
Senator Beck.
Yes.
Senator Bonner. Yes. Senator Brennan.
Yes.
Senator Brock.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Caldwell.
Yes.
Senator Cummings.
Yes.
Senator Dudley.
Yes.
Senator Ewing.
Yes.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hart.
Yes.
Senator Hashim.
Yes.
Senator Heffernan.
Yay.
Senator Engel.
Yes.
Senator Lyons.
Yes.
Senator Major.
Yes.
Senator Matto.
Yes.
Senator Norris.
Yes.
Senator Persia.
Yes.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
Yes.
Senator DeHoven.
Yes.
Senator Watson.
Yes.
Senator Weeks.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Senator Williams.
Yes.
The ayes voting 30 and the nays voting 0, and we have confirmed the appointment of William Schuldice. We now have the appointment of Adam Gresham as Commissioner of Finance for a term from and including March 1, 2025 to and including February 28, 2027, and until a successor is appointed and is qualified. For the report, Senator from Windsor. Senator Clarkson, are you the reporter? Maybe not. What does that say?
That is correct.
I'm sorry,
Mr.
it's kind of scribbly, and I can't decide if I should have my glasses on or off, trying to discern it.
Secretary. Adam Gresham. Adam Gresham, I'm delighted to report Adam Gresham, having served with him in the House for a number of years. Adam was appointed by Governor Phil Scott to be, as the Commissioner of the Department of Finance and Management in June of 2017. Prior to his appointment, Adam served as state representative from 2009 to 16. And he first served on House Education, and later he and I served together, sitting across from each other on House Ways and Means, and we had a grand time. Although he began his life in New York State, Adam has claimed New England as an adult. First, by coming north to Maine to go to Bowdoin College, and second, to go to Boston, where he got his master's degree at the Fletcher School of Law and Diplomacy, a useful degree for his work here in the State House. He worked in Boston for 16 years as a research analyst and lead portfolio manager in the Global Bond Group at Scudder, W. Stevens and Clark, and he is a chartered financial analyst. And third, he came to Vermont with his wife Anne and their 3 children to help run Sugarbush Resort as a partner and owner of Summit Ventures. As a result of Altera's purchase of Sugarbush in 2020, Adam is no longer involved with the resort at all. He has served on the boards of the Warren School and the Mad River Valley Health Center Board. He is a member of the Mad River Valley Rotary Club and the Mad River Valley Chamber of Commerce and the Friends of Mad River, just in case you get the Mad River connection. Adam spoke with our Senate Government Operations at length about his service in Vermont, how much he enjoys it and is challenged by this job, and why he would like to continue serving Vermont in this capacity. We talked about a number of things, but I just thought I'd end with talking about what he's proudest of. And we're proud of him for being proudest of these things. Almost 8 years of service in the Scott administration, one of the longest serving commissioners. A solid, long tenured department with no significant instances of fraud or abuse. And he views this as the department's most important deliverable. Many employees who cut their teeth in finance and management and went on to important positions elsewhere in state government. a customer-focused approach that provides expertise and analysis to other agencies and branches of state government. Your Senate Government Operations Committee voted 5-0 to recommend Commissioner Gresham for confirmation, and we hope that the Senate will confirm him today for another term as Vermont's Commissioner of the Department of Budget and Finance. Thank you.
The question is, shall the appointment of Adam Gresham as the Commissioner of Finance be confirmed by the Senate? Are you ready for the question?
Roll call.
Roll call has been requested. The Secretary will commence to call the roll.
Senator Baru.
Yes.
Senator Peck.
Yes.
Senator Boneyard. Yes. Senator Brennan.
Yes.
Senator Brock. Senator Brock.
Yes.
Senator Chittenden. Yes. Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Douglas.
Yes.
Senator Bueller.
Yes.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hart.
Yes.
Senator Hashim.
Yes.
Senator Heffernan.
Yay.
Senator Ingalls.
Yes.
Senator Lyon.
Yes.
Senator Major.
Yes.
Senator Matto.
Yes.
Senator Norris.
Yes.
Senator Pershling.
Yes.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Mahosky.
Yes.
Senator Watson.
Yes.
Senator Weeks.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Senator Williams.
Yes.
Those voting yes, 30. Those voting no, 0. And you have confirmed Adam Gresham as the Commissioner of Finance. This is the appointment of Kyle Harris as a member of the Cannabis Control Board for a term from and including March 1, 2025 to and including February 29th, 2028, and until a successor is appointed and has qualified. The question is, shall the appointment of Kyle Harris be confirmed by the Senate? For the report, I recognize the senator from Chittenden, Senator Vihovsky.
Thank you, Mr. President. Kyle Harris is being reappointed to the Cannabis Control Board. He came to the Cannabis Control Board from the Vermont Agency of Agriculture, Food and Markets, where he worked in agricultural development, focusing on emerging issues in economic development. His work was focused on the dairy innovation, maple initiatives, and hemp business development. He has worked closely with the Agency of Commerce and Community Development as a liaison between agencies to facilitate policy and economic discussion throughout Vermont's agricultural portfolio. Most recently, he aided in the development of Vermont's agriculture and food system strategic plan for 2021 through 2030. Prior to being at the Agency of Agriculture, Food and Markets, Kyle served as the Associate Counsel for Environmental Affairs at the Corn Refiners Association in Washington, D.C. In that capacity, he represented 14% of the U.S. corn supply, focusing on improving the environmental footprints at both ends of the supply chain, from grower relations to growth in the plant-based products and 21st century use of agricultural feedstocks. He has also spent time with the Maryland's Office of the Attorney General for the Department of Natural Resources. He has a Bachelor's of Arts from the College of Charleston in South Carolina, a law degree, and a Master's of Environmental Policy from Vermont Law School. And he maintains a license to practice law in Maryland. He lives in Roxbury with his wife, Kate. He reflected on his time with the Cannabis Control Board building up what we now know from nothing, and the pride that he has had in navigating creation of our regulated cannabis system. The committee asked him what his views for the future of the Cannabis Control Board were and what rules and regulations may need to change to further eliminate the illicit market. He clearly is deeply knowledgeable about agriculture and environment and is very well suited to continue serving on the Cannabis Control Board. Your Government Operations Committee voted 5-0-0 to confirm his continuation, and we ask for the Senate's support.
So the question is, shall the appointment of Kyle Harris as a member of the Cannabis Control Board be confirmed? by the Senate. Are you ready for the question?
Roll call.
Roll call has been requested. Are you ready for the question? The Secretary may commence to call the roll.
Senator Brew.
Yes.
Senator Beck.
Yes.
Senator Bungay. Yes. Senator Brennan.
Yes.
Senator Brock.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Douglas.
Yes.
Senator Ewing.
Yes.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hart.
Yes.
Senator Hashim.
Yes.
Senator Heffernan.
Yay.
Senator Ingalls.
Yes.
Senator Lyons.
Yes.
Senator Major.
Yes.
Senator Matto.
Yes.
Senator Norris.
Yes.
Senator Pershing.
Yes.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Mahowski.
Yes.
Senator Watson.
Yes.
Senator Weeks.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Senator Williams.
Yes.
The ayes voting 30, the nays voting 0. And you have confirmed Kyle Harris as a member of the Cannabis Control Board. We now have the appointment of Sarah Clark as the Secretary of the Agency of Administration for a term from and including November 17th, 2024 to and including February 28, 2025, and until a successor is appointed and qualified. The question is, did I get the dates wrong? I thought I was supposed to have those two dates. No. Oh, 2027, excuse me. Okay, to and including February 28, 2027, and until a successor is appointed and qualified. The question is, shall the appointment of Sarah Clark as Secretary of the Agency of Administration be confirmed by the Senate? I recognize the Senator from Rutland, Senator Collmore, for the report.
Thank you, Mr. President. Sarah Clark was appointed as Secretary of Administration in 2024 by Governor Phil Scott. Previously, she had been appointed as Interim Secretary in 2024 and Deputy Secretary of Administration in 2023. She has served the state of Vermont for 21 years as a leader in budget and financial management. She's worked in both the executive and legislative branches. For the legislature, she served as the Deputy Fiscal Officer, and that was with the Joint Fiscal Office from 21 to 23. In the executive branch, she worked for a variety of agencies and departments, including the Chief Financial Officer of the Agency of Human Services, the Deputy Commissioner of the Department of Finance and Management, the Financial Director at the Department of Corrections, and Interim Commissioner of Financial Manager at the Department of Forest, Parks, and Recreation. Prior to working for Vermont state government, Clark worked for the Office of the Comptroller of the Currency, which is a federal bank regulator. The Senate Government Operations Committee interviewed Secretary Clark, found her to be engaging, knowledgeable, and excited to continue serving as the Secretary of Administration, and by a vote of 5-0-0, we recommend her confirmation and ask the Senate to concur.
The question is, shall the appointment of Sarah Clark as Secretary of the Agency of Administration be confirmed by the Senate. Are you ready for the question?
Roll call.
Roll call has been requested. Are you ready for the question? The Secretary may begin to call the roll.
Senator Baru.
Yes?
Senator Beck.
Yes.
Senator Bonner.
Yes.
Senator Brennan.
Yes.
Senator Brock.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Douglas.
Yes.
Senator Bueller.
Yes.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hart.
Yes.
Senator Rashid.
Yes.
Senator Heffernan.
Yay.
Senator Ingalls.
Yes.
Senator Lyon.
Yes.
Senator Major.
Yes.
Senator Matos.
Yes.
Senator Norris.
Yes.
Senator Pershler.
Yes.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Mahovsky.
Yes.
Senator Watson.
Yes.
Senator Weeks.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Senator Williams.
Yes.
The ayes voting 30, the nays voting 0. And you have confirmed Sarah Clark as the Secretary of the Agency of Administration. That completes the orders of the day. Senator from Chittenden.
Thank you, Mr. President. I'd like to congratulate the Senate on almost getting to the end of the 2-week meat grinder that is crossover. We are very nearly there, but we are not there. So one of the last things we'll need to do is come back this afternoon quickly at 3 o'clock. We will have a short session to move an important housing bill and make sure it meets our crossover deadline. So with that said, Mr. President, I would move that pending announcements, the Senate stand in adjournment until 3 p.m. this afternoon.
Are there any announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1:45. We have a bill to get out before 3.
Senator from Windham.
Thank you, Mr. President. Senate Judiciary will meet immediately after the call of gavel briefly to vote out our favorite time-sensitive bill.
Senator from Washington.
Thank you, Mr. President. Senate Appropriations will meet at 1:30.
Senator from Rutland.
Thank you, Mr. President. The Senate Government Operations will meet at 2.
Senator from Bennington.
Mr. President, the Senate Education Committee will meet at 2.
Are there any more announcements? Seeing none, the Senator from Chittenden has moved that we stand in adjournment until 3 p.m. March 24th. Are you ready for the question? If so, all in favor say aye. Aye. Sorry. Today's the 20th. Yeah. 21? Well, let's try to get the date right. Sorry about that. The Senator from Chittenden has actually moved that we stand in adjournment until 3 p.m. March 21st. Are you ready for the question? If so, all in favor say aye. Aye. All those opposed, nay. The ayes have it, and we will stand in adjournment until 3 p.m. later this afternoon.